Hello, my name is Patrick.Bradley. Welcome to my subject matter expert vlog. Today's guest is Attorney Shanna Yonke with the law firm of Reuter Ware, and our topic is digital property. Shanna, welcome.
Thank you, Patrick. I'm happy to be joining you today.
Well, I'm excited about this because I understand you and your associate, Jessica Merkel, gave a presentation to the Wausau Estate Planners Forum. I had a chance to see the content and I learned a lot, and I'm sure our audience is much like me in that there are a few missing points when it comes to our digital property. So thank you very much for agreeing to share time and talk about it. So at the get-go, let me just say today's recording is April 14. The content that we'll be discussing is relevant as of today and certainly may change in the future. And to our audience, please do not construe anything that we are talking about to be legal, tax, investment, or insurance advice. And if you need help in those areas, please consult your appropriate counsel. So with that being said, Shanna, at the get-go, what is digital property?
Yeah, so digital property is a hot topic right now. It's we're kind of on the cusp of our clients actually owning digital property when they pass. There's really four main types of digital property. Digital property itself is a really general term, but the first type is digital accounts. So when you think of digital accounts, that's things like your email, your social media accounts, blogs, web hosting accounts, your domain names, all of that kind of property is a digital account. A second type is electronically stored information. So that's a fancy term for information that you store on your computer or tablet or cell phone, anything that you upload to a website, all of that is electronically stored information. A third type of digital property is electronic communications. So that's like emails and text messages, things that are electronic in nature, but that you use to communicate a message to someone. And then the fourth type of digital property are digital devices. So think of your actual computer or tablet or cell phone itself versus the information that you store on that device. So those are the four main types.
So, okay, so any cloud-based account where I may have my information. So as an example, mysocialsecurity.gov, where I can go and check on my benefits, that would be considered digital property.
That's correct. So your socialsecurity.gov account is a digital account. So you have a new username and a password, and that is your digital property.
Okay, great, thank you. So now, just out of curiosity, what happens if there are not any directions regarding my digital property upon my death?
Well, Wisconsin has default laws about how we deal with your digital property if you don't modify those laws in your estate planning documents. So our default laws in Wisconsin say that your fiduciary, so whether it's your personal representative or trustee upon your death or during your lifetime and you're incapacitated, it might be your agent under a durable power of attorney for finances and property, that fiduciary has access to all of your digital property with a minor exception. So your fiduciary does not have access to the content of your electronic communications. So remember, electronic communications are your emails and text messages. They can't view the actual message itself, the content of the message, but your fiduciary can get a catalog of your electronic communications, which would include things like the to, from, date, and time of those messages. So again, the default rule is that all digital property is accessible to your fiduciary except for that content of your electronic communications.
Okay, so if the proverbial bus hits me a little bit too soon, and my spouse, as an example, is my, well, let's say I'm incapacitated. So she is my durable power of attorney for finances, and she would have the right to go online to investment accounts, to Facebook. She can close down my Facebook account?
That's correct.
Okay. All right. So that's interesting. So with that being said, How do you suggest that we provide directions regarding our digital property?
Yeah, so let's say that you don't care for those default rules in Wisconsin, because most of us would be comfortable with our family viewing even the content of our digital communications. It might even be helpful or comforting for them. So in those circumstances, if you want more access than the default laws in Wisconsin allow, then you can include specific directions in your estate planning documents. So whether that's your will, your trust, your durable power of attorney for finances and property, all of these types of documents that we're drafting now as attorneys, they include specific reference to digital property and in fact authorize your fiduciary to access the content of your electronic communications. That's a conversation we have with clients because most of our clients we find are comfortable with the content being accessible to their fiduciaries, but not all. So that is a planning point. You have to consider whether the content is something you want to make accessible to your family. That's one way to deal with digital property when you're gone and be really proactive about it. Another way, and this isn't something that you can use with all forms of digital property, but some digital accounts allow this. So there are online planning tools. So things like the Google Inactive Account Manager for your Google accounts. And that is you might have a wide range of Google accounts and information on the Google Cloud, or the Facebook Legacy Contact. So you can go on your Facebook account and set a legacy contact, someone who is able to access your account when you're gone. So these types of online tools for certain types of digital accounts will allow someone to more readily access those accounts in accordance with the terms of the agreements with those companies. Essentially, the fine print that you never read or read when you signed up for your Facebook or Google account, it'll allow your fiduciary to access those accounts more easily. So there are those two different ways. Estate planning documents is absolutely superior in my mind, but online tools are really useful for specific types of digital accounts that allow those.
Okay, so just so I have this clear. So my son, as an example, is much more computer and online adept compared to my spouse. So if I went on Facebook and I could just name my son as my legacy contact, and then if I'm incapacitated or I died, he would be able to go in and close down that account and do whatever?
That's correct. So your legacy contact on Facebook or the individual that you identify through the Google Inactive Account Manager can be someone other than your fiduciary. That's completely permissible. And in fact, many of our estate planning documents identify someone that the trustee can retain, or that someone in your position might recommend they retain, for instance, your son, who can help with digital property because they might be more gifted in that realm than your fiduciary. So certainly you can do that using an online tool, and you can do it in your estate planning documents as well.
Okay, excellent. All right. So last question for you is, how can we make it easier for our loved ones to access our digital property upon our death?
Yeah, so this is an interesting question because while we can provide your fiduciary with the power to access your digital property upon your death in your estate planning documents, or we can name someone as a legacy contact through Facebook using an online tool, while those are options, sometimes it's difficult for us to locate and identify all of the digital property that someone has. In fact, I bet that if you and I sat down and tried to list all of the digital property that we have, we might forget a few things. So what we recommend to our clients is that they create a digital inventory. And for security purposes, we suggest that they create 2 separate lists as part of this digital inventory. Generally speaking, we recommend that they don't print these out. So it will be lists on, say, an Excel spreadsheet or a Word document, whatever works. And on one of those 2 lists, you identify the digital property, and you also identify the username for the account. So for instance, let's say I'm using my Facebook account. I would identify Facebook, and my username is my personal email address. So that would be what I would put on my first list. Then the second list would identify the digital property again, but then it would have the password. So one list has the username, the other list has the password. So in this way, we're keeping that separate. If somebody is able to access one of those lists, unfortunately, then they probably still won't be able to access your accounts. So we recommend that both of those files be encrypted. There is free software all over that allows you to encrypt. Microsoft programs, and I know Apple programs allow you to encrypt by using special tools within those programs. So you can encrypt each of those documents. Make sure that you provide the encryption key to someone that you trust. So whether that's your spouse, and it's in a special place like a safe at home, or it's your attorney who can keep that in a special location that is protected, then in any case, you want a trusted individual to have the encryption keys so that we can actually access those and we know where they are. So another way that we deal with this situation is that we'll have our clients save those two lists on separate external hard drives or USB drives, and provide us with the encryption keys for those and keep them separately. So that's one great way to make it much easier for your loved ones to identify and access your digital property when you're gone.
And then some sites also have, 3 unique questions and answers. I assume either on the username list or the password list, you would want to provide those also, right?
Yeah, absolutely. So that's another good piece of information for the dual factor authentication type questions, to include those on the digital inventory as well. Okay,
so another question for you. So some sites that I visit quite often for business reasons, I log in with my username, my password, and then they send me a code, a 6 or 7 digit code via text. So if I'm gone and my son, as an example, or my spouse as my power of attorney for financial affairs, would they need my phone to receive that code, or do they need to speak to a human being to get around that?
So it does depend on the company and the account, but oftentimes what we see with our clients is that they will have the cell phone because it's digital property, and they'll be able to access it because they have this digital inventory. So they know the passcode for the phone. So they're able to utilize the digital property that is the cell phone to actually access the other accounts. Now, again, that's not always the case. Sometimes the phone is inaccessible for whatever reason. In that case, we do need to work with the companies, but your fiduciary still has the legal authority to access the account. So we are able to gain access. It just takes a little bit more work.
Got it. Okay. All right, Shanna, this has been really helpful. Thank you very much. Any parting words that you'd like to share?
Well, thank you for inviting me on your vlog today, Patrick. I really enjoy talking about digital property. It is a hot topic. It's something that's kind of new for all of us. So I just recommend that all of our clients address this and make life easier for their loved ones when they're gone.
Okay, thank you. So to the audience, if you'd like to learn more about this, you can contact Shanna at routerware.com. All of her contact information is there. And I am going to be sharing a disclaimer as we close out our vlog today. Shanna, thank you again for joining us. I appreciate it.
Thanks, Patrick.
Okay, we'll wrap up. Thanks, Shanna.
Thank you.